Thank you again. I noticed that some of you were here since this morning, so thank you again for your patience. I just want the record to reflect that Justice Robert Toon is back with us on this panel, and Justice Joseph Diffkoff is no longer with us. I'll now call the next case, and I may need some help with pronouncing the last name of your client. Why don't you tell me that first? Papitis?
Jesse St. Gilles.
Okay.
St. Gilles.
Okay, thank you. So I'll call the case 2023-0582, and I'm going to need help with the name of your client as well, which I was first looking at. How do you pronounce your client's last name?
Pettipai.
Pettipai. Joanne Pettipai versus Jesse St. Gilles. Thank you.
May it please the court, Dana Kernahan for Jesse St. Gilles. We challenge the court's finding of unjust enrichment. There are two problems with that finding. First, unjust enrichment is available only if the party has no other remedy at law. And I think the problem that the plaintiff has is that this transaction is governed by a contract. And there were specific claims made on that contract. There was a claim of breach of fiduciary duty and fraudulent inducement that were brought but ultimately failed. The plaintiff could have also raised a common law claim that the contract was unconscionable and based on the inadequacy of the consideration, but she never raised that issue in her complaint and never raised that claim. But the point is that there were remedies at law that were available to her and that she pursued and that ultimately didn't succeed, and some of which she didn't pursue.
What if, could the relief here, what happened to the declaratory judgment claim? Wasn't there I thought there was a declaratory judgment claim somewhere in here?
I think that I think the claim was that the property should go back to her, and that
wasn't there a? I thought someone asserted a claim for a declaratory judgment.
I'm not sure. I'd have to look over the complaint again.
Because I have a note that there was a declaratory judgment claim, which doesn't mean that I'm right. And so my question was, why couldn't all of the relief that had been ordered here just have been done under the declaratory judgment?
Well,
which would be an equitable claim. It wouldn't go to your argument that, there was relief in the law.
I mean, the judge did specifically say, I'm ruling on unjust enrichment.
Right.
And that's the problem we have here. We don't have a challenge to a declaratory judgment count. And so I think that's where we are. If the judge is going to rely on that particular theory, that particular equitable theory, there has to be no other remedy at law. And
what?
Go ahead.
And why is it? Why isn't the theory of unjust enrichment broad enough to include others? What our courts have sometimes referred to as, quote, other circumstances? Well,
because I think the courts have been, this court and the SJC have been very clear that unjust enrichment is something that is very rarely invoked, very rarely allowed. If you look at the cases I cited in my brief, Bonina versus Shepard and Santagate versus Tower, those were both situations where there was no other remedy. There's no available remedy, and unjust enrichment was allowed. Pompanesett Beach Association.
But again, those cases don't say that if there was another cause of action, that precludes the creation of a constructive trust and going under a theory of unjust enrichment.
I'm sorry?
It doesn't say that it precludes the possibility. In other words, just because there was an absence of another theory or another avenue of relief in those, and there was an absence of another avenue of relief in the cases that you cite, you interpret that, as I understand it, to mean that there is a preclusion here, that if there is any other theory, that unjust enrichment is not available. Well, as a theory of
I am saying that, but not necessarily based on those two cases. When you look at the rest of the cases, you look at Pompanesett Beach Association and Taylor versus Woodrow, the courts rejected unjust enrichment claims where the plaintiff had a remedy at law. The Zelby case, which I also cite in my brief, talked about, reversed a motion to dismiss, but made it very clear that if there was a contract, there was a claim of unjust enrichment, these are alternative theories. If there was an action under the contract, then there would be no claim for unjust enrichment. At the pleading stage, the court said, both of them will survive, but not necessarily a trial.
Right. But on this issue, what I don't understand about this argument that you're making is through the unjust enrichment claim, the judge imposed a constructive trust, which is an equitable remedy, right? The jury, regardless if it had found in Petipas's favor, could not have imposed that kind of equitable remedy. So I don't understand the argument that the possible remedies at law precluded the judge from exercising her equitable powers under the unjust enrichment claim. Isn't that the problem here?
I don't think that's a problem. And by the way, the jury did come back on the advisory opinion in favor of Mr. St.
Right, but of course the judge isn't bound by an advisory opinion.
Right. And the judge said, I'm going to disregard it, and then focused on what is actually the second part of my argument, which is she focused on the lack of consideration, and said, or not the lack of the inadequacy of the consideration. And said, why would she have turned down $90,000 to sell the place outright when she'd have to, of course she'd have to move out immediately, and then go and take a deal that was much worse for her, where, her only real benefit is she gets to stay in the house. And, there are cases in this, I found them going back to 1858 saying, the inadequacy or the perceived inadequacy of the consideration we don't look at. Courts, if there's some consideration, then that's enough. And there was certainly some consideration here. She was relieved from her debt. She lived in the place rent-free, and Mrs. St. Gelais paid the closing costs and assumed other responsibilities.
I thought that the crux of the judge's decision turned on her finding that really that there was no understanding of the terms of the contract, that there was a misunderstanding, affirmative misunderstanding of the terms of the contract. That's what I thought it really turned on.
I think the plaintiff said, well, I didn't really understand. I thought there was a handshake loan agreement. And
It was like a one-year loan, and he knew I was going to, I was expecting money, I was going to pay it back in a year, I needed help in this crunch, and that's what my intent was in entering into this agreement.
Now, she went and consulted with her attorney, Bruce Bendixson.
It's a let's just say, messy set of facts.
It is a messy set of facts, but he said, this isn't a loan. Why don't you go and get him to give you a mortgage, or get somebody to give you a mortgage? Okay. This is a conveyance. You're giving up the property. This is not a good deal for you. And she said, I went against the advice of my attorney, and I went against my better judgment, and I agreed to it.
Because she trusted your client.
She trusted him, but that's not any reason to set aside the...
I'm just saying, that's the whole part of the other half of the story.
She is not an uneducated person. She had 3 years of college. She really wanted to stay in that house. That was important to her. And when St. Gelais said, look, you can sell me the house, obviously in these circumstances where she's about to lose the house within a few days, she's not getting market rate. There's no time for due diligence. Everybody knew that the septic system was problematic and would need to be replaced. The place probably needed to be torn down. There were all these things going on, so she wasn't going to get what she would have gotten a year earlier before this problem all took place. But he presented her with this offer, and she turned it down, and she said, I don't want to move. And he presented her with a second proposal, which was not a very good deal for her, as compared to an outright sale of the house. But are the courts in the business of saying, we're going to second guess every deal? She wasn't defrauded. There was nothing that was misrepresented to her.
But that's not required for unjust enrichment, correct?
It's not required for unjust enrichment. But again, there's got to be no other remedy. And I don't know why there's a set of common law cases saying, you can do, we don't second guess the amount of consideration. I think one of them was actually the Brookline condominium case that I think Your Honor wrote. There's a.
Go
I'm sorry.
I guess I would agree that second-guessing consideration would not be an adequate basis. But it did seem like what the judge here relied on was her finding that St. Gelais acted fraudulently by engineering the transfer of the property while causing Petipa to believe he would retransfer the property to her when she repaid the loan. So it was like this fundamental understanding of what was actually happening. I guess this seems like your strongest argument is if the finding of the judge on the unjust enrichment rested on a finding of fraud, but the jury already found that there was no fraud. So I guess my question is, what's your strongest argument that unjust enrichment is precluded when there is a contrary finding by the jury on a fraud claim?
Well, there was a contrary finding, by the jury, and that was never set aside or challenged. And I think to the extent that the judge said, well, I'm going to disregard that, she didn't reserve that as an advisory opinion. And she only reserved unjust enrichment, and she also didn't set that aside. So the jury came back and said there's no fraud. The judge actually directed a verdict on whether there's a breach of fiduciary duty. And, so what we have is unjust enrichment, as to which the jury said, no, he wasn't unjustly enriched.
Yeah, but I'm guessing, what's your best case to say that the judge can't do it? If there's a jury finding no fraud, not overturned, that the judge can't then impose a constructive trust under a theory of unjust enrichment premised on a finding of fraud. Is there any case you can point to say that's precluded?
I don't have anything off the top of my head. I do have cases saying that these circumstances don't support the imposition of a finding of unjust enrichment. Again, because, and there could have been a common law claim saying that there's, that the consideration was completely inadequate and that this was not necessarily a fraudulent contract, but an unconscionable contract. And cases going back 150 years or more have held that, and recent cases have held that, and that's a real problem for Ms. Petipas.
In Attorney Curran, the first page of the judge's findings of fact, I'm looking at page 36 of the blue brief. It refers twice to a counterclaim for declaratory judgment, and it says at the bottom of that page that the declaratory judgment counterclaim was reserved for the court.
I think the declaratory judgment, if I'm not, I may be incorrect, but Mr. St. Gelais wanted declaratory judgment saying that he was owed rent.
Okay, so it was just use and occupancy?
I think there was
just
use
that
and
piece?
occupancy because after the first year, and indeed for the last 6 years, she's not paid rent.
Okay, so it wasn't a declaratory judgment. Well, he's only entitled to use and occupancy if he's got title, right? Or if he has superior claim to the premises.
And that was his argument, that, at the very least, he should get reasonable rent or use and occupancy. He's paying the property taxes and the insurance and all the expenses.
So it seems to me that maybe many of the subsidiary factual issues are embedded into the use and occupancy claim, because if they go to whether he has a legitimate claim to the property or to rent, that would be part of the declaratory judgment counterclaim.
I'm not sure how to answer that. I think that part of the problem is that, they never agreed to a specific amount. And she said, well, I never agreed to pay rent. I was told about it at the closing, but I never agreed to it. Unless there are any further questions, I'll leave the remaining points to the brief.
Thank you.
Thank you.
Good morning, Your Honors. If it please the Court, John Walsh for Joanne Pettipa. I suppose first I'd like to address the adequacy of legal remedies. In this particular case, any legal remedy would be inadequate. The purpose of the lawsuit was to disgorge title for Mr. St. Gelais and to bring title back to Ms. Pettipa. And the only way I know how to do that is through the equitable remedy of unjust enrichment and imposing a constructive trust. I think
Could you have asserted a claim for rescission of the contract?
So there was no claim for rescission of the contract, and I think the problem with pursuing a contract action is
That wouldn't have been a contract action. That would have been a claim to rescind the contract.
but I think even if that was done, you still had the deed to contend with, because the property was deeded to Mr. St. Gelais, and any contract would merge into the deed. So I don't think that would give Ms. Pettipas the remedy that she was looking for and that she deserved.
What remedy had it been awarded, have the jury found in your client's favor on the fraud claim? What could have been ordered? Money?
Money damages.
Money damages, nothing else.
And the case I refer to was, it's in my brief, the Greenfield County Estates case, where it says that because of the uniqueness of real property and deprivation of title, an equitable remedy is really the only remedy which would make the client whole. And you've got to remember, it's not is there any alternative remedy available, is there any adequate alternative remedy available? And in this case, the only adequate remedy would be the imposition of a constructive trust to return title to my client.
Can you turn to the problem I have is the judge's decision cites the standard for imposition of a constructive trust. And she emphasizes on page 7 of her decision, she emphasizes A, fraud, B, violation of a fiduciary relation. The jury found against your client on fraud. The judge directed a verdict on violation of fiduciary duty. So I guess my question to you is it possible for the judge then to proceed under the unjust enrichment claim and find essentially for your client on the same grounds that have been rejected by her or the jury?
Well, yes, Your Honor, and I would add C, the expectations of the parties. I think the judge focused on the expectations of the parties, and it's clear from the evidence that the expectation of Ms. Pettipas was that she was receiving a short-term loan that was secured by the paperwork that she executed for Mr. St. Gelais. You don't need fraud to prove unjust enrichment. Because the judge reserved the unjust enrichment claim for herself, she can make independent findings from the jury. Not only is she allowed to, but I think she's obligated to make her own independent findings of fact, and she can disagree with the jury on that, and that's appropriate. But again, I think what the the judge
Do you have a
really
case that
focused
says
on.
that the judge can disagree with the jury's finding on fraud?
I'm sorry, Your Honor?
Do you have any case that shows that under an unjust enrichment claim, the judge can disagree with what the jury found on the fraud claim and rely on fraud as a theory to support application of a constructive trust?
I believe I do, if you give me a minute. I don't know if it says so in as many words. Yeah, I think I would refer to Weiler versus Bunnell Motors.
Right, and that's a 93A claim, which is somewhat different from
It's
another common law claim, right? 93A is kind of a special all-purpose cause of action, but I guess the problem here is that unjust enrichment is a common law claim, fraud, violation of fiduciary are common law claims, and so the question is, can the judge issue an inconsistent judgment based on one common law claim that goes against what the jury found on another?
And I believe, although the court may disagree with me, I believe the principle in Weiler applies here still, because the judge is her own fact finder and she can make her own determinations. But again, in this particular case, I think the court focused on the reasonable expectations of the parties. And the reasonable expectation of Ms. Pettipas, if you believe her testimony, the testimony of her lawyer, and the testimony of her significant other, was that she was going to get a short-term loan that was secured by the paperwork that she executed.
Is that a different basis for unjust enrichment than fraud? Is that what you're saying, that judge can find unjust enrichment just based on her understanding of the parties' expectations?
Certainly, certainly.
And that's a basis for imposition of a constructive trust?
Yes, it is, Your Honor, and fraud is not required. And I believe I have a case that mentions the expectations of the parties, if you give me a moment. Well, I have Cavati and DeEsso, which states that there's no requirement of fraudulent intent. And I know the trial court in this decision mentioned the reasonable expectations of the parties, and there is a case in my brief on that. And just the overall issue of fairness and equity. It's very broad, it's all encompassing.
So just to sum up, if I understand your position correctly, your position is that a party can have no intent to defraud, but still be unjustly enriched. Is that what you're?
That's correct, Your Honor. I wish I said it that way myself, but
Just want to be sure I understand your position.
so I don't think I have anything to add, but I would say this is not a case of buyer's remorse. Ms. Pettipas didn't sell her property and then say, gee, that was a bad deal, I should have sold it for more. Ms. Pettipas thought she was getting a short-term loan that was secured by paperwork.
She did consult with an attorney, though, who told her, don't do this, right? I mean, that makes this case a little...
No, she said, undisputed.
Yeah.
And she said, no, I trust him, he won't screw me. Guess what?
Okay.
So I don't have anything to add, I rely on my brief.
I'll just check with the panel, see if they have any additional questions they want to pose. No? No. Thank you both very much.
Thank you.
All right, having concluded the entire list for today, the court stands in recess. Right?
No.
Oh, we have one more case.
Halo versus
Oh, my
Ryan.
gosh, I apologize. Of course, we have one more case. I was thinking, why do we still have people here? Okay. And I thought it was a little bit early as well. All right. Next case, 2022-1171. I know, I'm a little worried about that.
Hi, how are you?
All right, I haven't called the name of the case, which is Chanteau. I'm going to say Prelure. Can you pronounce the name of the plaintiff, please, for me?
Shante Prelo.
Shante Prelo. Okay, Shante Prelo versus Oliver Ebe.
Yes, Your Honor.
Ebe, thank you very much. Okay.
Thank you. May it please the Court, my name is William Smith. I represent Mr. Ebe, and my co-counsel Jennifer O'Brien is here with us as well today. Happy New Year to everybody, too. I think this case really raises, I think there's an underlying theme in this case, which is the idea that, yes, we recognize, I mean, most, if not all, of the error here, or errors, are unpreserved. Yes, it's a bench trial. It's a trial without a jury, of course.
And it's a, and it's a civil case.
And it's a civil case.
Right, and so basically, the way I understand your claim, there is, first, well, so there's obviously the big issue of waiver. But it also sort of, when there's an absence of an objection, when there's no objection to evidence coming in, it sort of highlights, I don't know how to explain this. We only review cases to see if there was an error, right? First, there has to be an error in order for us to even do anything. So who made the error here? Because unless you can point to an obligation on the judge to have sua sponte excluded evidence, then I don't see how there's an error. Can you help me with that? Because there's no objection, right? The judge is normally supposed to wait for objections to come to him or her and then act on that objection, and then that's the action that we review. In this case, where there's no objection, even if we were to get past the concept of waiver, we'd still be stuck with that by saying, the judge's error was, what would the judge's error be here?
Sure, Your Honor. But there's also the case law that says that where there is plain error, and I would suggest here there is a myriad of plain errors, plural, that results in a manifest injustice, that nevertheless this court or the SJC could and should review it. And I would suggest if this was the case, if we were here, if this was, I don't know, maybe 2 or 3 of these types of errors where you had hearsay, not just hearsay, you had contained therein, you had conclusions, conclusory statements on the ultimate issue at trial, which is whether or not he had engaged in sexual discrimination and sexual harassment. I mean, you have all of that in this case. You have what could be otherwise would have been admissible prior bad acts evidence, potentially. Certainly, we recognize that that is not per se inadmissible for sure. But you have this evidence that is offered of these prior, I mean a plethora of prior alleged incidents where he had done this without any factual connection, that is to say, no factual foundation that would tie it in with what the live issue at trial was. So to answer your question, Your Honor, in a more practical manner, I would say yes, the judge, at least at some point. We acknowledged, I mean, for sure, our client was pro se, so we're not suggesting that some sort of special deference should have been given. But the case law does recognize, for example, with respect to the rules of civil procedure, that at a certain point, I mean, a pro se litigant, that it should be looked at by the appellate courts, that there's some type, the judge should be ultimately in a gatekeeper type function.
The judge can't become the pro se litigant's lawyer.
For sure.
So if the test is, as you're suggesting, manifest injustice, have we defined what that means?
Certainly, it's a broad premise, which I think your question gets at. But I do think, again, on a record like this where there are so many errors.
But
they go to the very
there's
heart-
also such strong evidence against your client.
Well, there was because of what came in the form of, otherwise this would have been essentially one person saying one thing, another person saying another. Two
And
different
so it would have
accounts.
just,
Right.
but
Not
here's.
necessarily, because there were admissions by your client as well to certain activity.
certain degree.
Just that there was rationales presented and other, and different contexts presented. But there were, of course, lots of corroboration, that the judge could find evidence of corroboration of the plaintiff's claims here.
But the corroboration, as you used the term, Your Honor, I mean, it came.
That was a nice term, more admissions toward.
Correct. But it came in the form, almost invariably, of evidence that was absolutely inadmissible. Even
Well,
if they-
let's drill down on that. So first, you just say that, I think, the first group of exhibits, the disciplinary letters.
Correct.
Right?
Yes, Your Honor.
So the judge, I can't remember him or herself, I don't remember the name of the judge.
She-
Herself,
she-
yeah,
she-
herself, yeah. On her own, said, well, wait a minute here, we have to take a look at this, there's a lot of hearsay here, right? So that was already reviewed in the beginning. And they were admitted for a limited purpose, correct?
Yes, but they were never stricken. And as to being admitted for a separate purpose, I would suggest, I know that the judge.
I said limited
Or
purpose.
limited for a
Limited
special purpose, but as we outlined in our brief, that separate purpose really had no applicability. This was all after the fact. So the idea that it constituted somehow notice or knowledge, well, I mean, this is long after the fact. So had there been, for instance, some sort of allegation that there was a subsequent, some sort of subsequent wrongdoing, okay, that might be a different circumstance, right? Because then the evidence would be offered that he had notice, right? But that's not the case here. This is simply, these were conclusions by the university that he had in fact been guilty. I'll say guilty, I understand.
But even if you disagree with how the judge limited their admissibility, okay, if they still were not admitted as far as the judge was concerned, for the truth of the matter asserted.
Correct, but even for that.
Can't we rely on the judge to appropriately instruct herself, and that the fact that
Sure.
that information was
but-
not used for that purpose?
I understand, Your Honor, I understand the call of your question, but then at what point does it become where, can we really do that? I mean, again, if all we were talking about were these letters, sure, different story. But this is a trial that consisted of this sort of thing, the entire trial. And I think at some point, the appellate courts have to look at this as, yes, understand, our judges are good, they certainly understand these distinctions. But when the evidence, as you used the word corroboration, but respectfully, the problem is all of that corroboration was part and parcel of these errors. I mean, I don't know about all of it, but maybe 95%.
I'm thinking about your client's testimony as well. There was many instances of information that came directly from him that did support the allegations that were.
But I would suggest,
the judge.
regardless, I mean, it still would have been just looking at this factually, if you excise all of these errors, it would have been a far closer case. And I think that it's just, I mean, at what point, again, I understand prior bad acts evidence, it certainly is admissible in the judge's sound discretion. But even that, I mean, there has to be some factual basis. You can't just get it in and say, well, you know, here's the evidence that this person in the past had engaged in this, right? Just the conclusion that they had committed sexual discrimination or sexual harassment in the
But
past.
didn't just with respect to the disciplinary letter, Prelo and Costin testify directly at trial, right?
Well, correct. One of
So,
them
I
did.
mean, so it's, what's the, even if you set aside the judge's own self-imposed limitation on this evidence coming in, what's the harm if the actual substance of their accounts of your client's harassment comes in anyway?
The harm is at least twofold, Your Honor. The harm is number one, well, but there was someone else as well, okay? And those statements were extrajudicial. She did not testify. And number two, it bolsters the testimony of I mean, that is, I believe, why the hearsay rule exists. We can't allow that sort of bolstering. That's at least one reason why it exists.
But you can to some extent under the bad acts rule. Right, there's
Correct,
some latitude
correct,
for that.
Correct, sure, for sure. But the policy, if you will, behind it, I mean, is precisely that the extrajudicial statements, I mean, even though you can cross-examine, he had the opportunity to cross-examine the person who did testify. The fact of the matter is he had no ability vis-a-vis the other person. So, but again, all of these, what we're talking about here, if that was it in isolation, no, we would have, it would be a different story.
But I think I just keep going back to my initial question to you because you repeatedly use the word errors and errors. What is the error? Who committed the error? Is it the judge? What did the judge do wrong?
Yes.
The judge admitted, the judge failed to exclude evidence sua sponte? Is that the argument?
Yes. I mean,
So what is your best case that says a judge has an obligation to sua sponte exclude unobjected to evidence?
I would not quite frame it that way. I would frame it that ultimately this becomes a manifest injustice.
I know,
And-
but that's not an error, right? I mean, we have to first identify an error. We can't reverse things unless there's some error. And I understand a whole bunch of inadmissible or potentially inadmissible. Let's assume that a bunch of inadmissible evidence came in. But no one objected to it, and it's a civil case. And so we'd have to say the error was that the judge should have done something that the judge didn't do, which is, I suppose, exclude it? Not
Yes, Your
consider.
Honor. I mean,
Okay,
yes.
so I'm looking for a case where we've said that the judge has that obligation.
Well, I can't.
It's just like a citation to a case.
I understand. Off the top of my head, Your Honor, respect, I can't stand here and say that I.
Then
I
the
would-
other question I have for you, because when you make your manifest injustice argument, the judge could not have reached the conclusion that she did unless she credited the plaintiff, right? I mean, she just couldn't have unless she had credited the plaintiff. Why doesn't that end the story? Because we know from the fact that the judge found in favor of the plaintiff that she credited the plaintiff. She had the plaintiff testifying live in court. That's an unreviewable decision by us. That's, her credibility determination. That's the end of the story. So in the end, how is this a manifest injustice?
Well, because the problem with that is yes, well, but then you could say that about any civil case. You could say, well, so, the rules of evidence, hearsay, the offering of ultimate conclusions as to what is the ultimate issue at trial, all of those, well, they don't really matter because ultimately the judge found in favor of the plaintiff. And I would
No,
suggest.
because in this case, it's the finding rests upon a credibility determination.
Well, but again, I mean, given the mountain of inadmissible evidence in this case, I think this is the kind of case that an appellate court should look at carefully. And if I could by analogy sort of answer your question a little bit, I do know that in the criminal realm, for example, I mean, certainly the case law says at some point the judge should intervene. And I understand this is not the same thing.
Sure, and we have a standard of review for unpreserved evidentiary errors in the criminal case, but we don't have that in civil cases.
Well, I mean, I think it's there in terms of the plain error and manifest injustice, plain error that leads to manifest injustice. And I would suggest that if there is such a case, that it is this one here today.
I want to talk about the fees and costs. Your argument about the fees, we would have to
Okay.
find an abuse of discretion.
Yes, that is the standard, Your Honor. And I understand, I mean, certainly the judges are given a wide range of, all I would ask the court to consider in that, I don't dispute at all that my brother, certainly very experienced in this area, no question about it, that was established. I would just ask this court to consider the fact that when we had a hearing on that, and when the judge considered that the judge simply did not take into account in full what was counsel's delineation timesheets of what had transpired. I would suggest it was simply a lot. This was not a jury trial. I understand for sure, I mean, we have to prep for jury trials no matter what, but still this was not a jury trial. There was, and I would suggest simply, it came out in terms of the aggregate amount of time as quite a lot.
And so if we were
not
to,
disputing his hourly fee.
if we were to agree that maybe the judge needed to take a different kind of look there, that would just go back for?
I think so. I mean, I think that is what would have to be
Okay.
done. So again, I mean, we had the letters, we had the email, and again, it isn't just that it's hearsay, it's what that hearsay brought with it.
And actually, your time, I'm looking at the
I'm
flashing
sorry.
light. No, I just want, I
sorry.
also saw that you had some seconds left, and I just
The
wanted
last
to
time
double
I
check.
looked, it was
Yeah.
green, so.
That's all right. So your time is actually up. Did you want to take just a one-sentence summation? I didn't want to cut you off in the middle of your last sentence.
No. Just again, I would suggest that if there is an example of a manifest injustice in this type of case, this is it.
Okay.
Thank you.
Thank you very much.
Thank you. You know, what would be an interesting appellate argument here would be the admissibility of I'm calling it the Me Too evidence about Mr. eBay or Dr. eBay's, we say, modus operandi of sexually harassing women. And at the trial, I boxed vigorously with Judge Sullivan, trying to get in the evidence about the student who said he tried to feel her breast with an office door closed, was not allowed to get that in. I boxed with her over getting in the evidence of the Georgia Tech student from the mid-'80s who said that he closed the door on her and tried to kiss her. She would not let that in. What we did get in was Ms. Costin, who testified live, was cross-examined by Mr. eBay, and that was classic, about what he did to her. And the consistent, or kind of the eerie evidence of that one that made it really, really poignant, I think, and the judge had to admit it, was the fact that he used that same scheme where he sent her the email about polygamy being allowed in the Nigerian culture, just as he'd done to Ms. Prelo. So that evidence did not come in. Now, here's this concept of sua sponte, and I love old Latin. Judge Sullivan, sua sponte, kept that out. And she tersely told me, and I finally stopped trying to get it in, especially on the Georgia Tech evidence, because we had taken the deposition of that witness. Mr. eBay didn't bother to attend the deposition. She's down in Georgia. And I think that the situation was eerily similar. So under the exception, it could have come in, but it didn't, okay? Didn't come in. So whatever these mountains of errors are here, those aren't mountains. They're not even hills.
And one of the issues that they raise, I'd just be curious in your response to this, is that, well, this is a jury waived trial. So you're making this compelling case for the omission of, for example, one of the incidents, right? And the judge ultimately excludes it, but you've already made the case to the ultimate fact finder about this evidence. So is there some line in which you introducing that evidence, even though it's ultimately excluded, that you shouldn't be able to cross because you're informing the judge, the ultimate decision maker in the case?
I think that's an interesting question, okay? And if it was the kind of evidence that was ridiculous and obviously not possibly relevant and prejudicial in some crazy way, maybe. But I think, okay, or the plaintiff thinks, that Judge Sullivan should have admitted that evidence. You can't get any closer. It's a scheme. This is what he does. He uses his position of authority in academia with young women who he plays this game, of this grandiose game he plays about how wonderful he is when he has authority, okay, gets him in his office, shuts the door, and makes moves on him, okay? The plaintiff testified live about that. I had Ms. Costin testify about it at the same place. Now, there's 2 other people out there who said the same thing. And he was asked all about that at his deposition, okay? So I think, yeah, we could hypothesize about an attorney trying to do the best job he's doing for his client, which I was, obviously, in being reckless and unfair to some poor pro se litigant. But boy, we're not getting close to that here. This is evidence that I think, and frankly, I think Judge Sullivan kept that out because the rest of the evidence against Mr. eBay was so overwhelming, there was no need for her to even think about it, okay? And by the way, I just want to mention this because the thought finally came up in my mind as I was thinking about this Mr. eBay's predations and what he does, okay? And I remembered that I learned about that. I used to coach youth hockey. And in order to get certified to do that, you have to take something called safe sport, which it's a necessary evil these days, but basically you are taught about what sexual predators do, how they work their schemes to try to get their ultimate goal. And uncontested evidence in this case from Ms. Prelo went right along with that game plan. This professor of engineering, he engineered this thing from the beginning. And well, let's just review some of that because it's uncontested. The initial lunch meeting where he starts asking Ms. Prelu about her dating, about her racial preferences, about her sexual orientation, and then he ends the meeting by saying, oh, by the way, I can erase you at any time. Okay,
I don't think there's any dispute that there was sufficient evidence.
Okay, so this happened.
The only question is sort of, was there any kind of evidentiary error here? And
There were, first of all, I don't see the error, and I dealt with, there was obviously from the appellant's standpoint, a lot of arguments about that. In our brief, I addressed those. Frankly, I think that letter comes in because he could have appealed it.
Are you talking about one of the initial letters?
Yeah, the initial letter where he's disciplined. He had the absolute right to appeal that. He got demoted.
And you made that argument. You made the argument that it was an admission, but the judge did not.
No, I went over with Judge Sullivan on my attempt to get these in beyond what she would take them for, or just exclude them. So we did our best, and frankly, whatever this rule is that we might be contemplating imposing on attorneys, it wouldn't be in this case because Ms. Prelu has the right to present her best case and make those arguments, and I can't believe anybody would say that any of those attempts to get evidence in were made in bad faith or whatnot. This is not the case for that.
There could be some kind of bad faith limitation, particularly when you're going against a pro se opponent, but you don't think it got close here with your arguments, that they were reasonable arguments to make, even if you ultimately lost.
No, and when we add in the man calling her and telling her that he wants to put a baby in her, okay, and her testimony that made her vomit, that she came to Lowell, okay, as a first-generation person in her family ever to go to college to mentor kids in the STEM field, and she ended up dealing with him in his constant come-ons. And it wasn't just the girlfriend, this is our anniversary date stuff. It's also unconsented touching, leading up to him shutting the door in the office, in her office, in trying to grab her and make the moves on her. Okay, so this formidable barrier to employment, check. Unwanted sexual overtures, check. Damages,
I'm having a hard time understanding to what legal point your argument is going. Is it all going to it doesn't seem directed to whether there was an evidentiary error. I suppose you're arguing that this is not a case of manifest injustice?
I was not aware of the manifest injustice standard until today, but this is not a case of a manifest injustice. Just relying on my brief, the reason we led with that argument is, you can argue all you want that maybe if Mr. Uribe had actually objected and the judge let evidence in, what they're complaining about, that was error. But it's not the kind of error, severe error, I've quoted the standard there and everybody knows it, that would require the verdict to be overturned. The evidence I'm going over with you, I should have said it before I started, was uncontested evidence of sexual harassment here. So Judge Sullivan was certainly well justified in reaching the verdict here, finding Mr. Uribe liable for sexually harassing Ms. Prelo.
Did you want to, did you want to address the attorney's fees before your time is up at all?
This case is now in its 7th year, by the way, okay? So there was no unusual amount of activity from me in representing Ms. Prelo. The time to have contradicted that was in the Superior Court, and Judge Sullivan did not make that finding. I don't see how it's possible or really fair for her to be second-guessed on appeal, and that was our argument on that one.
Okay.
I have nothing further.
The panel has no
Thank
further
you.
questions either. I'm glad that I was reminded there was one more case. It was a very interesting one, and I thank you both for your briefs and for your argument today.
Thank you.
Now we have finished the list for today, and the court will stand in recess.